But yeah, it was a fun to watch him out there doing the soccer.
Yeah.
All right, so it looks like everybody's coming in here. Good morning, everybody. Welcome to another edition of Community Cafe. This morning, we've got Sophia Kandt back again this morning. Today, she's going to be talking to us about the 5 ways that you can make sure that your home is protected, home and other assets are protected, and end up going to your kids or whoever you want. Whenever we do estate planning, we've talked about this in prior times, we want to make sure our assets go to who we want, when we want, the way we want. And Sophia is going to share the 5 ways when it comes to our home, and it applies to other assets as well, but we'll primarily focus on the home. So good morning, Sophia. Welcome back to Community Cafe.
Thank you very much.
All right, so you know, as an attorney, that this is one of the big issues we have is how do we protect the home? And so when we're talking about protecting the home, kind of walk us through, like, what are we, when we say protect the home, protect it from what? Because there's various threats that are out there. So kind of walk us through what some of those are.
So sometimes we want to protect the home from probate. And probate is just, upon your death, if you have assets left in your name, you don't have a beneficiary named on them, or another owner, then your assets go through probate, and then court case and all that. So probate is one thing we want to protect our assets from, and then another thing that we want to protect our assets from are creditors potentially, and just making sure that we, whoever we want to receive those assets are actually the ones who are going to receive those assets.
Yeah, so the probate, I always tell people, probate is really, if we boil it down to its essence, probate is the process by which we take property that's titled in the name of somebody who's dead, who's no longer living, and we retitle it to the name of somebody who's alive. And that's what probate court does for us, but it does have to go through that legal process. So assets you own in your name at the time of your death without any other owner on there, maybe as a joint tenant, and we're going to get to that, or beneficiary, we'll get into that, I'm sure, that then those are assets would have to go through probate.
I'd also say another way we can protect our property would be from Medicaid as well. So, if we want to apply for Medicaid, we just need to make sure that we're protecting it so that it's not, part of our accountable asset. So
I think that's a big one for a whole lot of people. So, we don't want the house to go through probate. We want to get it to our kids or whoever our beneficiaries are. We certainly don't want the state to come, throw a lien on our home and take the home from us because we need it to, go into nursing care or something like that. So we want to protect from Medicaid. And then there's just the general concern of protecting from creditors, right? That we get sued and that. And so, and that'll vary from where your home is located. So we're going to be let's touch today on that topic on both Kansas and Missouri. So if you would, talk to us just real quickly before we get into the 5 ways, but let's talk about homestead exemption for Kansas, and then let's talk about for Missouri, because there are some big differences there depending where you live. So maybe to walk us through that a little bit.
So in Missouri, if you own a home and you want to gift the home.
Well, no, I want to talk about not gifting. I want to talk about homestead exemption. You get sued. Somebody comes in and sues you, and your homestead exemption in Kansas and then Missouri, or whichever way you want to talk to them first.
Mm-hmm. So I'll let you talk about the Kansas one, but the Missouri one, if you are sued, I think you can exempt up to, I believe it's $15,000, right?
Right.
From your property. So
right, you get a claimant exemption of $15,000, and let's say we've got a husband and wife who own the home jointly. They don't get each claim $15,000. A total of $15,000 exemption that is protected that creditors can't claim. But any equity you got above $15,000 on the Missouri side is subject to creditor claim. So if you get sued because you ran over somebody in a parking lot or whatever, and you're at fault, and they sue you. So make sure, one way to protect your home is make sure you're adequately insured, right? Get an umbrella policy. They're cheap. They come in $1 million increments. Go buy it. That. Now on the Kansas side, in Kansas, we're fortunate. We have an unlimited homestead exemption. You could have a $25 million home and they can't touch one penny of the value of your home. So our home is completely protected in Kansas, but that's not true in Missouri. So protecting from lawsuits is one way. All right. So that's just big picture of, what our home is. We're trying to protect from probate. We want to protect it from Medicaid, so the state throwing liens on it. And then we want to protect against lawsuits and ultimately just make sure that our assets go to who we want, when we want, the way we want. So let's get into the 5 ways that predominantly we can do that.
Right. Okay. So one of the ways that we can do this, and let me start this PowerPoint. Okay, it would be through joint tenancy. So joint tenancy is just, you own the property with another individual. And so joint tenancy is this way that upon your death, the other is, it's a right of survivorship. So upon your death, the other owner gets to now be the sole owner of that property.
So let's take a husband and wife situation. Husband and wife own their home, joint tenants, right of survivorship, right? The most common way people own their home. So they own as joint tenants. Is it protected from probate?
Yeah. For one individual. So I guess the short answer is no. The home in its entirety is not protected from probate. So upon the first spouse to die, the remaining spouse gets to own the whole property, and so the house doesn't go through probate at that point. Upon the second to die, the house would go through probate. Yeah.
And why?
Well, we don't have a beneficiary named, possibly we don't have a beneficiary named on the house. It's that person's property now. So it has to go through probate. Right,
because we had 2 people entitled. First one died as joint tenant, no problem. Joint tenant was right of survivorship. Last one standing wins. So, husband dies, wife now owns it in its entirety. But if she does nothing more, when she dies, now it's subject to probate. Why? Because there's nobody living on title. So we're going to have to go through probate process. Okay, so joint tenancy delays probate, doesn't avoid probate. It just delays it on the first to die. What about from Medicaid? Does joint tenancy provide us protections for Medicaid?
It can. It can provide some protections for Medicaid. I would say you probably want to meet with an attorney before just, adding a joint tenant to your property. I would say most of the time, the short answer again is no, it's not going to protect the property from Medicaid. If you add your child to the home and then you want to apply for Medicaid, the property is still subject to, it is still your property, right? If you are a joint owner, you are essentially a 100% owner as well. So it is subject to Medicaid if you apply.
Right. And so, and Sophia, you bring up a point and this is always the thing we have as attorneys, right? It's like, well, yes and no. I mean, there are so many, the law is so broad and you can couple a lot of these. In fact, a lot of these 5 ways we're going to talk about today aren't done in isolation. Sometimes it's a combination of the 2 to go in. And I would just encourage people, work with an attorney when you're doing this stuff. We want to make sure, as I said earlier, our assets go to who we want, when we want, the way we want. We want to protect it from lawsuits. We want to protect it from, Medicaid and any claims being on there. But there's no one way to do this. And there's a lot of factors that come in and it can get complicated. But yeah, I would agree. Joint tenancy, it has its place with Medicaid, but as a general not. So we got back to the husband and wife. Husband and wife own it. And, we'll just continue to pick on husbands. Husbands got to go into nursing care. Well, it's not that they're going to take the home away from the wife. She gets to continue as long as she's able to live in it. She's there, but the state will throw a lien on the home, right? To get reimbursed for all the money they're spending to pay for husband's care. And so then ultimately that home's not going to pass on to the kids. So joint tenancy, we could get into, well, what if you add your kids into joint tenants? And sometimes that strategy can work, but it's generally not the preferred way that we're going to do that for a whole host of reasons that we wouldn't want to do joint tenancy. So joint tenancy delays probate, doesn't avoid it. It's really not a protection against Medicaid. It just, causes a lien, and as long as the spouse is living there. But if we don't have a spouse, we've already lost a spouse, and now it's the wife who has to go into nursing care, they're going to throw a lien on it, require it to be sold, and then that money to go through the spin down. And then against lawsuits with joint tenancy, you're back to your home exemptions, right?
Right. That's not you don't get the you don't get protections from just having a joint tenant owner. No.
So, okay. So joint tenancy is one way, but by itself, it's not a real strong protection we have. Let's go to number 2. How do we protect our home? Second way we can look at that. So, or I'm sorry, 5-way to ensure their assets go to where we want and protect. So talk about probate.
So probate. Okay. So this is if you own property upon your death, most of the time, your property will go through probate. So that, like, this is what we talked about, is the court case. A judge is ultimately deciding where your property goes. So if you don't have a will, or if you have a will or don't have a will, you're going to go through probate.
Go ahead.
So I was going to say, this is, if you have we're going to talk about this a little bit later, but a beneficiary named on your property, it's not going to go through probate at that point. So, but this is a way that, we ensure that the property is going to someone, but I guess through the probate process, you can decide who you want it to go to by way of, if you have a will in place. If you have a will, through your will, have you stated where your property goes to your children, to your friend? If so, then great, you've chosen where that property goes. But what happens if you don't even have a will in place?
So the door to probate is broad, right? It's a wide door. There's multiple ways to get into probate. Now, probate ultimately is going to decide where the home goes. So let's talk about ways that people commonly end up in probate.
Mm-hmm. So like we said, one, I guess, do nothing. If you do nothing, your home upon your death is going to go through probate. So if you want to, do no estate planning at all, you're not adding a joint tenant, you're not adding any beneficiaries to your property, upon your death, your property is going through probate.
Okay.
And then you want me to talk about the other way?
Yep, absolutely.
Okay. So another way would be, you have a will. You've done your will, but your will still has to go through probate. So it still has to be probated upon your death. So, you can say, I want my home to go to my friend or my child. So then upon your death, your will has to go through probate, and then and the property has to go through probate as well. And then in the end, your property gets to go to who you want. So you get to choose, but it still has to go through probate.
So the what you've talked there are 2 ways. So when we do nothing, right? And do nothing might have been an incomplete plan, right? Back to our joint tenancy, your first way. We have joint tenancy, just delay probate. We didn't have probate at the first spouse to die, but when the second one died, or the second joint tenant dies, whether it's spouse or not, now there's nobody living on that's alive, that's on title. And so we have a probate issue. Because what is probate? Process by which we take property that's titled to somebody who's no longer living, and we get it to somebody who's alive. So if we do nothing, we have no plan at all, and it's going through probate, we call that
intestate.
Right. So it's going by laws of intestate. Mm-hmm. And then the second way you brought up is when we're passing it by way of a will. And you're absolutely right, Sophia, as you bring up. And so many people think that we do wills to avoid probate. And we've talked about this in prior community cafes. Wills do not avoid probate, even though that people commonly think that's true. They don't. It just tells the court who's to receive it. Right. So if we're going through probate, it makes sure that our assets go to who we, if we've done a will, to who we want. If we didn't do a will and we're going through the laws of intestacy, it's going to go in to your heirs at law as determined by the court, correct? Mm-hmm. So, right. Obviously, this doesn't avoid probate. We're using probate as a way to get property delivered. So we failed on that. Will it protect us from Medicaid? Can probate be used?
No. No,
No.
because probate, the only time probate's used is upon your death. So, no, it doesn't protect you from Medicaid.
And we could use probate for guardianships and conservatorships, but they're not going to allow the conservator to divest the home of the person and shield her from that. So it's not going to protect us there. And obviously, it doesn't provide us any with the protections of against lawsuits and that. So we're back to our homestead exemptions. Okay, so probate is typically what we're trying to avoid, and it is a way to pass on our property, but generally not the one we're going to choose. So let's look at way number 3.
Okay, so way number 3, transfer on death deed, and some may know this term as a beneficiary deed. So, this is just adding a beneficiary on your property. So, in Kansas is transfer on death deed, Missouri it's beneficiary deed, but you're just recording a deed with the county saying upon my death, this individual is the beneficiary of my property. So that property does get to avoid probate because upon your death, it avoids probate because it goes to that individual. Now, that individual upon their death, it may now go through probate. What happens if that individual is not living at the time of your death? May still go through, the property still may go through probate. So it's not a sure way to avoid probate, but it's a good start.
Right. Yeah. I always tell people the beneficiaries have to do their part and stay alive and well, right? Because if they don't, well, then it didn't work. But transfer on death, I think if our sole goal is just to avoid probate, a transfer on death deed is an easy, inexpensive way to do that. And we can do, not on our home, right? Transfer on death deed, we can do it on our home, but we can do transfer on death or pay on death, beneficiary designations on virtually everything we own, our vehicles, our bank accounts, our investments, IRAs, all that. So transfer on death then protects us against probate, as you said. Does it help us with the Medicaid question?
No. Nope.
Yeah, only comes into play at death. So it doesn't protect there. Does it do anything to protect us from lawsuits if we get sued?
Nope. It's still your property during your lifetime. It's like that transfer on death deed or beneficiary designation that you've made. It doesn't matter that you have one.
Right. So we're back to our only protection, our home. If we're in Kansas, we're lucky. Well, our home, we don't have to be worried about lawsuits because, our home is protected. Unless it's the mortgage company, or somebody we gave a voluntary lien to on our home, with very, very small exceptions. There are a couple exceptions. They're very, very rare. But our home is protected. On the Missouri side, though, this is more of a concern because there's only a $15,000 exemption. So protecting against lawsuits becomes much more of a concern for those people who live on the Missouri side of the state line. All right, so transfer on death deed has its place, but probably not the best way if we're trying to protect the home. But it does avoid the probate process and gets our home to, who we've designated on there. What's our next way of protecting our home?
All right, so Christmas is coming up. Do we want to gift the home or your property to an individual? So this is a way to ensure whoever you want to get the property gets the property. You can gift it to them, but there's, as we're going to talk about, lots of pitfalls to doing this as well.
Okay, so gift, and this is one that we see frequently where it kind of the do-it-yourself, right? People, they've heard something, read something, they're going to just gift it by, what do we mean by gifting? I guess let's explain that first, and then we'll get into why you might do that.
So there are, lots of ways we can gift property to people. We can gift it by way of, we can just add them as a joint tenant. If we want to gift our property to our children, we can add them as a joint tenant, like we talked about in the first, I guess, slide. We can just, gift it to them by doing a deed or just transferring the ownership of that property to your child, that would be a gift.
Right. We're doing it while we're still alive, right? And those are the two ways that we see it. And there's various reasons they'll do it, but they either add their children on as joint tenants. So now we're back to what we said earlier, where okay, we're combining these things in. And so I just met with someone, I guess it was end of last week. I'm trying to think if it was this week, end of last week. But this is what happened. Mom put him on as joint tenant during her lifetime because she trusted that he would make sure that the home was taken care of for the brother that she didn't. She wanted to be able to live in the home, but so there were some things. And there's pitfalls, and he's already, this person's already dealing with some of these pitfalls that come in with that. And the other way is just outright, hey, I'm going to take my name off the deed and I'm just deeding it over to my kids. And that's deemed to be a gift at that point because I've gifted. So does gifting protect us from, probate? Does it avoid the probate process?
If you gift during your lifetime, yeah, it will avoid probate.
Sure. Absolutely avoids probate. Why? Well, as long as their beneficiaries did their part and they're alive at our death, we're no longer the owner of the property. We don't have to go through probate. So it avoids probate. Does it avoid Medicaid? Protect us from Medicaid?
Potentially. That it depends kind of thing. So yeah, it depends. You can, if you've gifted it prior, 5 years before you apply for Medicaid, it could protect it.
Yep, subject to the 5-year look back, but as long as you did it 5 or more years before you went to nursing home. So you can't do this when you got your foot in the door at the nursing home. Yeah. You got to do it, 5 years in advance, but it can absolutely avoid probate. So wow, this is looking like a pretty good option here, right? It avoids probate, it protects from Medicaid. What about lawsuits? Does it protect against lawsuits?
If you're sued, it does, but if whoever you gift it to, it does not protect from lawsuits there. So if you gift it to your child and now they're, in a lawsuit or a bankruptcy or divorce, that property is subject to their creditors.
We just subjected our property to the claims of our kids, and it can get caught up in, if they go through a divorce, get caught up in the divorce, it can go through bankruptcy, it can go through, so there's all kinds of issues that go there. So from that standpoint, yes, it protects if we get sued, as long as we did that gift. We can't run somebody over and then immediately run and transfer the home and expect that that's going to protect it. But if we had done so prior to the event that we're going to be sued for, gifting can be a way to do it. So that's all sounding pretty good, but talk a little bit about some of the pitfalls that we see with gifting and why often we say, yes, while I can do that, this is not the correct option that we're going to choose to protect the home.
So if you, let's say for taxes, okay, so if you gift the home to your child, you're going to run into some, you may not get some tax deduction that you may have otherwise got if you just gave it to them upon your death. So when you gift the home, you're hurting your children because they're not getting that step up in basis that they would have got otherwise. And so they're subject to the value of the home would be, or I guess what can I think of the term,
I'm not sure which term you're looking for there, but with the home, what they're doing, when we gift it, they acquire our basis, cost basis. I don't know if that's the term you're looking for, but
appreciation is what I'm looking for, but yeah.
So it's our cost basis. So husband and wife purchased a home, let's say 30 years ago, and let's say they purchased it for $100,000 and the home's now worth $200,000. What does that look like for the kids?
All that $100,000 appreciation that you have there, that's, so if you gifted it upon your lifetime, you don't get that appreciation. So the value that you get the property for is the value that, the individual who first purchased the property, got it for. So you don't get any of that tax.
We acquire the basis. So husband and wife buy a home, $100,000, they gift it to their kid. Kid holds on to the home for mom and dad's lifetime, which is
Mhm.
frequently what I see because that was the intent, right? But we don't have any probate issues. If mom and dad had to go in the nursing home, it was almost done more than 5 years ago. Medicaid can't come and throw liens on the home, and so the home was protected. But we didn't really do our kids any favors because when they go to sell it, they acquired the original cost basis of the home of 100,000. The home's now worth 200,000. They're going to pay capital gains taxes on that $100,000 of gain. The other pitfall we oftenly see with the gifting is, as you said already, we've subjected it now to the claims of our kids. And so the more kids you put on there, if you got 3 kids and you gift it to all 3 of them, now you're subjecting it to all 3 of those kids, any claims they may have against the property. You've given up control of the property. And then what we see commonly people do is they'll only gift it to one child, like that scenario I talked about, the person I met with last week, where mom gifted to him, but now we have issues that it's all his property. So now for him, if he were going to try to get it to his siblings and divide it up, now they potentially have tax issues because he's doing the gifting now. So gifting, would you agree, Sophia? I mean, it's one of those things that it has its place, and it is something that we will sometimes use, but it's not for a home that's been owned for long periods of time because we don't want to deal with the seller. But if it's a recently purchased home or something like that, maybe a gifting can work, and especially if we only have, maybe 1 child or 2 kids and they're very stable. I mean, it can have its place.
Right.
But gifting as a general rule is not going to be as good as our next way. So let's talk about the last way that we can gift or get our property, protect our property.
So this is trust. You've established a trust and you're funding your trust. So your trust now is the owner of these assets. So, the home is the example that we've been using. So the trust is the owner of the home now. So lots of benefits of having a trust, and this is a great way to ensure that your property goes to who you want, and really avoids a lot of those pitfalls that we talked about in the earlier slides.
Actually, trusts are just fantastic estate planning vehicles. So does a trust avoid probate? Protect us from probate?
Yep. As long as so I see a lot of times, clients have a trust, but it's really just a fancy piece of paper, expensive piece of paper, because they haven't funded that trust. And that happens all the time, and you're shaking your head, and I think you agree. So it happens all the time that, in order for the trust to work, you can't just create the trust, but the big step is you actually have to fund the trust. So transfer your assets to the trust, or, even just like naming the trust as a beneficiary. That's the way upon your death, it's funded to the trust.
Yeah, you've got to get there. And yes, that's something that we constantly, it's why in our firm, we like to do the annual review meetings. We help them get, we take care of the deed to get the home in and work to get the trust funded. And then we want to meet with our clients annually to make sure through the passage of time, that they haven't just taken everything out of the trust, because that is a common issue we see with trusts, is they're not properly, funded. We haven't got the assets in there. So they only provide protections to assets in there. But if we get the home into the trust, we don't need probate, right? Trust owns it while we're alive. Trust owns it while we're dead. Probate's unnecessary. Well, let me ask it this way. Can a trust provide protections against Medicaid?
It can, depending on the type of trust that you have, but it can provide.
So a properly structured trust can provide us with the Medicaid protections.
Mm-hmm.
Does it avoid the 5-year look back?
No.
Yeah. So just like gifting, anything we transfer to a trust still subject to 5-year look back. So it's not to say that we wouldn't do it within 5 years, but we're going to have to do some other things as well. So, ideally you do this prior to having that foot in the door at the nursing home. Do it 5 years max. So protects us from probate, can provide us protections from Medicaid. What about lawsuit protections? Can trust provide lawsuit protections for us?
It can. So if you're, whoever, like we talked about before, if I want my child to receive my home, and I put it in trust, if they're sued, the home is protected while it's in the trust.
So we're out of time here. We could go into, and we've kind of talked, well, we've talked in depth about trust before, not specifically to the home, but in prior editions of this. But trust are fantastic planning vehicles. But as you said earlier here, Sophia, it's not necessarily the only way. And there are, certain circumstances, many times. I would say number two, if we're not doing trust, what's our number two way that we usually do it?
By way of will.
Or transfer on death deed, right? If we're doing a will, we're also usually using that TOD to avoid probate. So using that combination of the two. So lots of ways that we can do this. Guys, it's something I would encourage you, if you've done a plan, review it, pull it out, make sure that your plan, that you've got some protections in place of how you can protect it. But there's lots of ways you can protect your assets. I would highly, highly encourage you, whether you work with us or work with some other attorney, work with attorneys who do this type of planning, who understand things. All right, Sophia, thank you for being a guest again on here and kind of walking us through that. For viewers, next week, we're going to be having a roundtable. Mark Roberts with Affinity Asset Management, Christian Tillman from First Option Bank and Trust, and myself will be doing a roundtable. And we're going to be talking about COVID and really our experiences of how we've managed our respective businesses and what we've done in light of COVID, how it's changed some things. So I think kind of an interest. I'm interested to hear. I know a little bit about what they've done, but I'm going to find it interesting to hear what the other two are doing, and we'll share what we're doing as well. So hope to see everybody next week on Community Cafe. Sophia, again, thank you so much.
Very welcome.
Take care. Bye-bye.
Bye.